International Covenant on Civil and Political Rights, General Comment Number 6, Rights to Life. 1. The right to life enunciated in Article 6 of the Covenant has been dealt with in all state reports. It is the supreme right from which no derogation is permitted even in time of public emergency which threatens the life of the nation. Art. 4. However, the committee has noted that quite often the information given concerning Article 6 was limited to only one or other aspect of this right. It is a right which should not be interpreted narrowly. 2. The committee observes that war and other acts of mass violence continue to be a scourge of humanity and take the lives of thousands of innocent human beings every year. Under the Charter of the United Nations, the threat or use of force by any state against another state, except in exercise of the inherent right of self-defense, is already prohibited. The committee considers that states have the supreme duty to prevent wars, acts of genocide and other acts of mass violence causing arbitrary loss of life. Every effort they make to avert the danger of war, especially thermonuclear war, and to strengthen international peace and security would constitute the most important condition and guarantee for the safeguarding of the right to life. In this respect, the committee notes, in particular, a connection between Article 6 and Article 20, which states that the law shall prohibit any propaganda for war, para. 1, or incitement to violence, para. 2, as therein described. 3. The protection against arbitrary deprivation of life, which is explicitly required by the third sentence of Article 6, 1, is of paramount importance. The committee considers that states parties should take measures not only to prevent and punish deprivation of life by criminal acts, but also to prevent arbitrary killing by their own security forces. The deprivation of life by the authorities of the state is a matter of the utmost gravity. Therefore, the law must strictly control and limit the circumstances in which a person may be deprived of his life by such authorities. 4. States parties should also take specific and effective measures to prevent the disappearance of individuals, something which unfortunately has become all too frequent and leads too often to arbitrary deprivation of life. Furthermore, states should establish effective facilities and procedures to investigate thoroughly cases of missing and disappeared persons in circumstances which may involve a violation of the right to life. 5. Moreover, the committee has noted that the right to life has been too often narrowly interpreted. The expression inherent right to life cannot properly be understood in a restrictive manner, and the protection of this right requires that states adopt positive measures. In this connection, the committee considers that it would be desirable for states parties to take all possible measures to reduce infant mortality and to increase life expectancy, especially in adopting measures to eliminate malnutrition and epidemics. 6. While it follows from Article 6, 2-6, that states parties are not obliged to abolish the death penalty totally, they are obliged to limit its use and, in particular, to abolish it for other than the most serious crimes. Accordingly, they ought to consider reviewing their criminal laws in this light and, in any event, are obliged to restrict the application of the death penalty to the most serious crimes. The article also refers generally to abolition in terms which strongly suggest, paras 2, and 6, that abolition is desirable. The committee concludes that all measures of abolition should be considered as progress in the enjoyment of the right to life within the meaning of Article 40, and should as such be reported to the committee. The committee notes that a number of states have already abolished the death penalty or suspended its application. Nevertheless, states' reports show that progress made towards abolishing or limiting the application of the death penalty is quite inadequate. 7. The committee is of the opinion that the expression most serious crimes must be read restrictively to mean that the death penalty should be a quite exceptional measure. It also follows from the express terms of Article 6 that it can only be imposed in accordance with the law in force at the time of the commission of the crime and not contrary to the covenant. The procedural guarantees therein prescribed must be observed, including the right to a fair hearing by an independent tribunal, the presumption of innocence, the minimum guarantees for the defense, and the right to review by a higher tribunal. These rights are applicable in addition to the particular right to seek pardon or commutation of the sentence.